Today on Everyday Injustice, we have Kristina Kersey. She works at the National Juvenile Defender Center. Welcome.
Thank you for having me.
So what does the National Juvenile Defender Center do?
That's a great question. So first of all, we changed our name in January of this year to the Gault Center. And the reason for the name change is what we've started referring to as dropping the J. We really wanted to move away from the use of the word juvenile. And we had really started pushing our defenders to move away from the word juvenile and to kind of start correcting all the stakeholders against using the word juvenile. And so we figured we really can't do that and then continue to have juvenile in the name. We renamed ourselves after the Supreme Court decision in Re Gault, which stood for the proposition that youth are entitled to due process rights, just like adults, the right to an attorney, the right to an appeal, the right to a transcript and cross-examination and all those things that we feel very strongly about. So we thought the Gault Center was kind of a perfect name. So the Gault Center is really focused on excellence in youth defense and defending youth rights in general, and really specifically access to really qualified, specialized, trained defenders, hungry, zealous advocates for youth in the courtroom. So much of what we do is train mainly defenders. We have a lesson series that's specifically for youth defenders, where we train about raising race, we train about structural racism, we train about cross-examination, we train about adolescent development, and all the topics that we just think are really important. And so we've trained defenders. We also have regional centers. And so we really try and do technical assistance for the community and bring the communities together. That's in all 50 states, in Guam, Puerto Rico, Virgin Islands. And we have co-directors that kind of inform our work and what we need to address. We have publications. We have standards of what we want youth defense to look like. We do some amici work, and so we file briefs on issues related to adolescent development and youth defense. We do a little bit of everything. So those are the main things that we're doing over at the Gault Center.
So it sounds like your preferred term is youth. I'm going out on a limb, but maybe you could explain why juvenile is not a term you like anymore.
Sure. I mean, I think so much of our work, so we did partner with Fair and Just Prosecution, with the National Council of Juvenile and Family Court Judges on this language guide, and we really started talking about how to use youth affirming language, why it's important to refer to youth by their names and not the juvenile, and othering the children that find themselves in the delinquency system. And so the move away from juvenile was like that move away from othering kids. Also, we really felt that it's a dog whistle. There's nothing positive connected to juvenile. You know, when you Google it and you have like what's going to come up next, it's always delinquent. And so it has really negative connotations, and it's also similar to thug and all these. It's just become like a dog whistle for the racial disparities and for the overrepresentation of Black, Latin, Indigenous youth in the system. And so we really wanted to move away from the term juvenile. I mean, the reality is, right, like, so this is my favorite juvenile. This is my nephew, Quincy. I never refer to him as a juvenile, right? Like, I don't say like, oh, here are my first day of school photos of my juvenile. We don't talk about that, about children that we love and children we care about. And it's only when we talk about youth that are in court that we start all of a sudden start throwing around this term. And I think it's a way of putting distance between ourselves and the youth that we're representing and that we see in court. And we really want folks to start embracing the fact that these are children, these are youth, and we should call them that.
Yeah, and I think that's a good point. I mean, you know, juvenile is not really a word that we use anymore. other than, as you say, when we're talking about like juvenile delinquency or juvenile court or juvenile services or something like that. So that makes sense. I just hadn't heard it before.
Yeah.
And I try to keep up on language, but that one was new.
Yes.
So it seems like a never-ending struggle that I'm never going to win, but that's okay.
Always. We're doing our best.
So let me ask you, what is your background and how did you get involved in working with youth?
So I started with the New Jersey Office of the Public Defender. I was a frontline youth defender for 18 and a half years. And it really is, for anybody who's considering it as a job, it's really one of the best jobs. I loved it. I loved being in court. I loved representing youth. I'd like to say that I have a story that I really went into law school thinking that this would be what I was going to do, and that's just not accurate. I had a background and I had volunteered at a camp for many, many years, all through law school, all through undergrad, even into high school, at a camp for kids with learning difficulties, physical differences. And so I had always envisioned maybe working with children, and then decided I wanted to go to law school, thought I would do some policy things. That was really my interest back then. And ended up working at a law firm that did some federal representation. And I ended up going with one of the partners to the Union County Jail in the middle of summer and was like, this is what I want to do for the rest of my life. I want to get people out of jail. And ended up going to the New Jersey Office of the Public Defender. Someone was going out on maternity leave. And so I started in the youth section and never looked back. It was just exactly where I wanted to be. It's a practice that is so important, so under-recognized, and it just calls on a lot of different skills, not only to be this really intense trial advocate. You need to cross-examine, you need trial skills, those are basic, but you also need to be able to really connect with youth and their families and learn that dance as well, because the client, even when they're very young, is still the child. And so that puts you in some interesting situations, but it's great work for anybody who's interested. Reach out to me.
And I would be remiss if I didn't mention that I found out you're located in Asbury Park, which for Bruce Springsteen fans out there, you all know it's the home of Bruce Springsteen.
It is. It's like the birthplace of Springsteen. Yes. So I actually took new headshots and I took them in front of Madame Marie's as like an Easter egg for Springsteen fans everywhere. No one got it, but for Springsteen fans, we get it. So yes. I love Springsteen, and I love that I live in a town where I can like walk past something and be like, oh, he sang about that in that song.
All right. So one thing I wanted to talk about is an interesting case where you were the trial attorney in the state in the interest of N.H., which unfortunately sounds like you guys othered your own client, but you got to protect their name anyway, so I understand. But what was that about, and how did it get all the way up to the Supreme Court?
Yeah, so N.H. was charged with a homicide. I represented him in New Jersey and Essex County, and in New Jersey, unlike all states, there is a procedure where you can try youth as adults. In New Jersey, it's what they call a discretionary waiver. The prosecutor has a discretion as to whether or not to file a motion to try a youth and adult court. And so N.H. was charged with a homicide. The state had filed a motion to try him as an adult. And I had requested their complete file. So full and complete discovery, which would be everything that they had on the case. And that was really the issue, and they disagreed with what a youth was entitled to at that stage in the proceeding. And it was an unsettled area of the law. to me, it seemed very settled. It seemed like once a complaint was filed, I was entitled to discovery. So a complaint had been filed. I was entitled to all of their discovery to represent NH at this motion for transfer to try and keep him in youth court. And the state disagreed. They were essentially saying that this is somewhat of an in-between. This is just a jurisdictional hearing. This is really just about whether he's going to be in youth court or in adult court. This isn't a full trial. This isn't a fine resolution of the details. And so they weren't required to give me everything that I was demanding. And so that's essentially how it ended up in front of the Supreme Court. It was a somewhat unsettled area of the law because there was no court rule that really talked about what youth were entitled to at a transfer hearing. And so it was also kind of in between changes to our transfer statute. And so I think the courts were really interested in how this was going to work in practice. And so that's how we ended up in front of the Supreme Court. It was a slow process. I think we were almost waited 3 years for a decision from the Supreme Court on this one issue. And there was a stay, so nothing happened on the case other than me going and visiting NH in the detention center to let him know, what I had heard from the appellate division. And so, yeah, we waited 3 years, but it was well worth the wait. It was a unanimous decision written by our Chief Justice Rabner, and it gives youth the right to full and complete discovery in the state of New Jersey. And what's been great is that we were just talking about it recently. When you look on Westlaw, NH has been cited 45 times in New Jersey on all different arguments as to building on rights that youth should have at waiver hearings. Should youth be entitled to Miranda hearings prior to a waiver hearing? Can they call experts? What does that look like? And so it's been really exciting because we've been able to use a lot of the language from that really talks about what a monumentous decision this is. This is a huge decision. It's what's been described as the most weighty decision that a youth court can make, because you essentially rip a youth out of youth court, which is about rehabilitation, and you pretend that they're an adult. And that's just a fiction that we've created because they're not adults. But it does mean that then they could face very lengthy terms in prison and in many states, life in prison. And so it's an important case. I'm happy to be a part of it. And NH was just also just a wonderful client who had the patience while we kind of fought this out in the appellate division and then into the Supreme Court.
And this is, a really interesting area because, even in my limited time of covering stuff, we've really, our understanding of the development of the youth brain has really advanced very rapidly. I live out in California, and so, the laws have changed very dramatically just in 10 years. We've gone from the DA having almost complete discretion, at least in certain types of cases, to what was called at the time direct file in adult court, to now it's completely shifted the other way. And they have, in a lot of cases, they have to file for a transfer to adult court. And in some cases, if they're under, I want to say the age of 14 now, they can't. They can't go to adult court at all, which, for some cases kind of on that bubble is a little bit problematic, but it just shows how far things have gone in a very short period of time.
Absolutely. And I mean, I would push back and say, right, it's not problematic. It's something that we've created, right? And so I know that there are progressive prosecutors who have run under the banner of not trying children as adults. And while for the United States, 14 is better than some states. You know, in 2016, New Jersey removed 14-year-olds, and so they raised the age to 15, right? And that was a great step forward. I would have loved it to have been higher, but I'm happy that we're at least taking 14-year-olds out of the mix. But the reality is that in other countries, they're still sort of flabbergasted that we don't have minimum ages of prosecution, and more than half of our states don't. So very young children could be tried in our system. But that's, the UN Council on the Child talks about a minimum age of 14, even for involvement in youth court. And so in that respect, the United States is behind on how we treat children. And certainly this idea of how long they can spend in prison if they are transferred. We had a group here from Ireland, and they were flabbergasted. They couldn't believe it. There are limits, 10 years, 12 years, automatic look backs, opportunities of parole, and all these safeguards in place for youth that end up in their prison system. So they were really overwhelmed with what we had in our system.
And what have we learned? I mean, I often get this, some kid commits a horrible crime at the age of 17, and people want to say, well, this is adult conduct, so they should get adult punishment. Why do you think that's not the case?
So I'll say this, right? So for those of us that went to college, like those college years were, at least for me, when I did the most adolescent things, the most ridiculous things. And many of us, if not most of us, were over the age of 18. And so there is this idea that we can all conceptualize about 18, 19, 20-year-olds doing really ridiculous things while they're with their friends away at college. And we don't ever, I don't think any state has a waive back provision where we say, hey, they were 19 and they were just being really adolescent, we should try them as youth. Like, that would be ridiculous. No one would agree with me with that. But we have no problem saying the reverse, that there's, some 12-year-old out there, and that this behavior is so adult that we have to treat them as an adult. I also would kind of take issue with this idea that, like, what is actions that are as an adult? A lot of the details of these offenses are still really within the realm of adolescence. I think about N.H. and the factors that are in that case, right? So there's peer influence. He's not by himself. It's not like this well thought out plan. It's spontaneous, right? It's like in the heat of the moment, really unlikely to reoccur, not thinking long-term consequences, right? These are all the things that we know about youth. And what the research says is that's not even ending at 18. That's really ending more in the early 20s. And some would say maybe like 25. So even when you do have a 17-and-a-half-year-old, and usually what they're talking about more is like a serious offense, they're talking about homicides, they're talking about carjacking, right? Like, it's not that you have this 17-year-old that has like a Ponzi scheme, right? It's not Ocean's 11. It's not this well thought out plan that you're talking about. You're usually talking about something that happens in the moment, not thinking about long-term consequences, which is exactly what we're talking about when we're talking about adolescent behavior. And even though there are very sad stories that go along with that and very serious behavior, that doesn't make it any more adult. If anything, it shows just how adolescent they are.
Yeah, and I think that's a good point. It is interesting though, like in California, while we don't have like a look back mechanism, we do have a youthful offender provision that allows youthful offenders to actually appeal for early release. So, there is some consideration now being given to that.
Yeah, and I think Vermont is the first state that they've now expanded their youth court for certain offenses over the age of 18. So they're moving towards 21. So I think that this thought process and adolescent development is really taking shape in a lot of these states, like New York, like Vermont, like California, where they have either blended sentences or extended youth. that kind of runs into the adult court. And so we're starting to like embrace those concepts for real.
And also, the real fascinating thing is I don't think people give enough consideration to age, because if you look at like the criminal trend line, basically, criminality kind of peaks, at least for a lot, in that early age, and then you actually get to the point where people pretty much age out of crime. Like, by the time they get to be my age, they just don't commit crimes anymore. They have better things to do, or they're too tired, or they finally gotten over their childhood trauma. I don't know what it is, but can you kind of speak to that?
Yeah, I mean, so what I think you're talking about is Mulvey's study, which is called the Pathways of Desistance, where he basically looked at a large number of youth that had been involved in the system when they were younger. And he looked at all different groups, youth that had been involved in like, very minor offenses, youth that had been involved in what we would call violent offenses. And then he kind of tracked them for years afterwards. And what he saw was that there was this natural tapering off. And what we really use that is for the proposition that like we don't have to start servicing and panicking because a youth has some sort of offending behavior, something that's been classified as against the law. It's not a reason to start sending them away to residential programs or packing their entire calendars or putting them on electronic monitors, because what Mulvey is saying is that most of those youth are going to age out of that behavior. And the second part of that study, which I think sometimes gets lost in the sauce a little bit, is that he talks about the fact that some of the youth that actually continued getting into trouble when they were older were actually the youth that had a ton of conditions and surveillance placed on them as a result of the offending behavior. So it's not only, okay, a youth gets caught with marijuana, let's give them all the services and really jump in and do all the work. We could actually be doing harm by over servicing and overreacting to youth behavior. So one, we need to just hang on. They're going to age out of a lot of this. But two, we need to be really careful about how we intervene, because we could be doing more harm than good by allowing them to learn those tools in order to make better decisions in the future. And one of the things is like having tools to be in a situation and make better choices, having positive social interactions, having support mechanisms. And what do you do when you take a youth out of their community and send them to a residential program or send them to a youth prison, or you take away all autonomy? You tell them when to eat, when to sleep, what to wear. You take them away from their families and their communities, and you take them away from the gifts that they have for their communities. And then you don't allow them to participate in those like first jobs and mowing lawns and doing all the things that all of us experience that helped us become the adults that we are today. And so by overreacting, we actually are setting them up for recidivism.
Yeah, and I was just reading a new study that just came out that found exactly that, when early intervention actually is counterproductive. It makes them more likely to get involved in the system and more likely to commit future crimes.
Sure, and I think it's just reframing how we think about it. I think that there is just this thought that curfews are going to help a situation, or why not restrict them to their home? Then I'm going to know where they are at all times. And then they've done studies where they've talked about curfews. And again, they're talking about not individual curfews, but curfews like in a town where you can't be out past 16 at a certain age, that didn't do anything to decrease either victimization of youth or victimization by youth. And so these blanket curfews, they don't really work. And I think that our inclination is that that's going to help a situation. If youth aren't out late, then things are going to be better. And so there's this natural inclination to add that into every probation order, and keep kids home and have that curfew violation potential. But what we also see is that that's not, that's not been normed. It's not valid. It's just kind of our gut feelings about what we need to do to help youth.
Yeah, and it makes sense, right? Because the youth that are going to be out late and causing problems are the youth that are probably not getting a lot of parental guidance and supervision. And so, putting an artificial barrier on that's probably not going to do that much.
There's also the piece that, like, about surveillance, and the fact that what we want to do is we want to build youth that are going to be contributors to their society, and we want healthy, happy, well-formed youth. I think that's what everybody agrees. And by putting like electronic monitors and telling them they can't go places and putting rules in place just to put rules in place when they're not really making a difference doesn't really assist in that. And we're spending a lot of money. The courts are spending a lot of money that could go to credible messenger programs or diversionary programs that are valid and do help change public safety. And although I don't like the word rehabilitation, right? Like, this idea of what helps youth and what helps the community is not necessarily, we're just going off of our guts, and we're just not always right. And so I think that there's now this embracing of data and research and reform, and there's a lot of camps out there that are looking at those and looking at what works and pushing reforms based on evidence. And so I think that the courts and systems are responding to that.
And we've kind of built, this system based on a false premise. There was a fear, wasn't that long ago, that the youth were becoming these super predators, and they were operating without any kind of remorse, and they were, a true danger to society. And so we built this system that, allowed these kids to get thrown into adult prisons. And then we discovered, oh, wait, this actually isn't happening. And trying to undo that has been difficult.
It's been really difficult. I'm glad you raised it. So, the super predator myth, and it is a myth, it's been classified as a myth. When it came out, now looking at the data, the youth crime rate had already begun to drop. So while there had been this small uptick that they had relied on in coming to this super predator myth, the reality is at the time it was released and all these newspapers were kind of really clamoring and posting all these stories about youth, and they were just racial tropes, right? Like, it was very dehumanizing. Going back to language, you hear terms like wilding, you're hearing about packs of teens roaming the night, right? Like, it's not even human language that they're using to describe these kids. It was incorrect. One never came to pass, but at the time it was voiced, it was wrong. And we have not recovered from that. And Black and brown youth in the youth justice system have not recovered from that. You saw an answer to the super predator myth, states adopting transfer provisions that made it easier for them to try kids as adults. You saw mandatory minimums cropping up. You saw changes to purpose statutes around this narrative. And even now, when we've now all recognized that it was a myth and we were wrong, rolling back a lot of these provisions that sprang up in the 90s has been really difficult. And one of the fears that we have is that we're now in the midst of, potentially, depending on who you listen to, of a small uptick in youth crime, potentially, in crime in general, right? So there's been some articles around that. And there's been other articles saying, wait a minute, it's only some crime and it depends on how you characterize the rate, because usually it's per person. So in New York, for instance, they do it based on like number of subway rides. And because we were all hunkering at home because of COVID-19, the number of riders was smaller, and therefore, even if there was a decrease in the number of incidences, it could appear to still be an uptick. And so there is this concern that people are going to overreact to what's going on. And that's the second piece of the super predator myth, is that it focused on this small uptick, but it also didn't talk about the fact that we were in the middle of a recession, and that we had, what we referred to as the crack epidemic going on at that time, and that there were all these other things at play, which they weren't taking into account. And so that is a little bit of a fear in the community that we're going to see an overreaction to what's going on now, similar to what we saw in the 90s. But my hope is that we've learned our lesson, and that we're going to put the right things in place and not overreact to what we see as potentially an uptick.
And one of the classic overreactions was probably the Central Park 5 case. You reminded me when you were describing the fear of wilding. And, here was kind of, now we recognize it as a classic, wrongful conviction case where they interrogate these kids for hours without their parents, and they browbeat them into false confessions, and and it was all based on all these assumptions that none of which were true.
Right. Yeah. So for the exonerated 5, I love that this story is now part of the narrative between When They See Us and the Ken Burns documentary, right? Like, people seem to really have reinvested in this story. And I think that, many times people will bring it to me and talk about like how outrageous it is. And my response is like, it's not that outrageous. Like, this is just one story that we got right in the end. But so many things had to fall in line for it to be rectified. It's just as easy that their story would have never been told. And that there are many youth that are in prisons right now that are no different from the exonerated 5. And that we came dangerously close to not knowing the truth of that story. So when I started doing youth defense, it was the kind of thing where people kind of had never heard of it. And I think a lot of these stories raise these issues that we train around. Khalif Browder, that's a tragedy, but I think a lot of people didn't even realize that 16-year-olds could be on Rikers Island. And so that started a conversation about solitary confinement, and youth that end up at Rikers Island and what kind of services they are, and mental health. Like, it started conversations around those things. But there's lots of Khalif Browders out there, and there's lots of exonerated 5s out there, and there's lots of Centoya Browns out there. And those stories, I'm glad that they're getting attention. But I think the takeaway is, right, we have to do better, because unfortunately these stories are not aberrations. They are stories about what's happening in our system.
Yeah, and Khalif Browder is another really good example. I mean, talk about minor offenses, and he ends up in custody for as long as he did, in solitary confinement, and then just wrecks him, and we don't think about that, right? I mean, the mental anguish that this kid had to go through due to stealing a backpack? I mean, right. Or allegedly anyway.
Right.
I mean, that's crazy.
Right,
and yet
right.
It happens.
Right, and that does start to generate conversations around bail and on criminal justice reform, and so I'm happy that we're beginning to have those conversations. I'm sad to keep having those conversations and keep hearing about youth like Khalif Browder that have experienced the system in that way, but I think that they've become really important examples of what can really go wrong. I think that there's this myth that youth court is completely benevolent, and that there's really not, what's the worst that's going to happen, and these are examples of the worst that can happen.
Now, the one issue that we haven't discussed yet, which we need to, is basically the criminalization of Black youth, the racial disparities. And, just wasn't that long ago, I had this conversation, about the fact that ordinary teen behavior when it comes to Black and brown children gets criminalized. Things that, me as a white upper middle class kid in suburbia did, that ends up ruining the lives of countless Black and brown kids.
Yes. If I had to say that there's one thing that is most problematic about the system, that would be it. It would be racial disparities. And they are at every stage in the proceedings, right? It's which kids get arrested, and which kids get diversions, it's which kids get probation, and which kids get informal, which kid gets residential programs, which kids get prison, and which kids get waived to adult court and tried as adults. And the data is the data, right? So we also have talked about when it's white victim versus when it's a Black victim, right? So if it's a white victim, 2 times more likely to be tried in adult court. You can tease out all of the details, the disparities are there, the numbers are there, you can't ignore them. And it's incredibly problematic. So we talk about, the use of marijuana, and Black and white youth use marijuana or try marijuana at the same rates when they're teenagers. Black youth are disproportionately more likely to end up being arrested and prosecuted for the use of marijuana. And what we've also found is that white youth are more likely to try some of the designer drugs and prescription pills and things like that. But the numbers in arrests don't reflect that. It's over policing in neighborhoods. It's police in schools. So Kristen Henning, who's an expert on this topic, has a book called The Rage of Innocence. And in that, she really dives into the history of police in schools, which was a complete eye-opener for me. I think, like a lot of people, I assume that police in schools happened as a result of Columbine, and these really sad and these really sad school shootings. And the history of police in schools is desegregation, and really standing in the way of desegregation of schools. And then you see federal money being given more towards schools in the wake of Columbine and some of these school violence incidences, but they're not going to those schools. They're going to schools where Black and brown youth are. I don't know about you. I didn't have a metal detector or a police officer in school. Kids were getting into fights, kids were selling drugs, kids had all sorts of problems that easily could have resulted in them getting arrested. My school handled it in-house. If you have a hammer, everything looks like a nail, right? So if kids get into fights, which isn't something laudable, but it is normative adolescent behavior, and you have a police officer on grounds, then they're more likely to get records. And so you see this, what we've now termed the school to prison pipeline, where there are schools that have police officers that also don't have counselors and things that schools rely on when they don't have a police officer standing at the front of their school. It's just the way it is. And that's before you start talking about implicit bias or explicit bias or adultification, and the fact that Black youth are seen as older, they're seen as less innocent, right? They do all these studies where they give fact patterns to individuals, and in some they indicate that the person is Black, and in others they don't, and then they vote whether to give harsher punishments. And the fact of the matter is, in the fact patterns where they believe that the person is Black, they vote more often to give harsher punishments. And so that is a very large issue that we have to train on, that we have to build reform around, because we really just have not gotten at that issue yet. The number of youth in prison may have declined in some jurisdictions, but disparities also have increased in those same jurisdictions. And so a rising tide does not lift all boats. It's not happening.
Yeah, one of the stories we had Kristen Henning on a few weeks ago, and one of the stories that she told was this boyfriend and girlfriend got into a fight. She was accusing the boyfriend of having photos of other women. She like smacked him and took his cell phone. And because there was a police officer on campus, the school resource officer, he sees it and he ends up arresting her and charging her with robbery. And so here's an act that, you know, isn't really criminal or shouldn't be treated as criminal, and it gets criminalized just because you have a police officer on the campus in the first place, which you probably shouldn't, and B, because the police officer apparently lacked all common sense and decided to turn this into a big deal when it shouldn't have been.
Right. That's the perfect example. I know she also talks about her client that makes the Molotov cocktail, like a drama student. And I've seen those as well, right? Like, it's curiosity. It just depends on who's reviewing those facts. I had a client that was accused of trying to create napalm by like lighting a soap dispenser on fire, right? Like, so, and when I read it, I thought, like, this has just been charged incorrectly. There's no way that this is what he's being charged under. And that is in fact what they wanted to charge him under. And so a very similar type fact pattern being in a same high school, being interesting. Yeah.
Point these examples out because people have in their mind that the reason there's disparities in the system is that more Black and brown people commit crimes. And a lot of what I see is that a lot of these disparities exist because they get charged with things that wouldn't be considered crimes for other people.
Sure. That's one of them. And then there are also, there's also just charging decisions in general. Who gets diversions that get expunged right away and who doesn't. And then when that person, if they come in contact with the system again, who has a prior record and who does not. There's all these points of decision making. And when there's decision making left unfettered, left unchecked, there's a chance that there's going to be a likelihood that bias is going to creep in. And that's the reality.
Well, unfortunately, we're out of time, but I really appreciate you coming on and having this discussion. I think this is an issue that not enough people pay enough attention to. So thank you so much.
Thank you. Thank you for having me.
Kristina Kersey from the Gault Center. I'll get the name right this time.
Lovely.
Out of Ashbury Park, New Jersey. I got to say that again.
You have to.
Thank you so much for coming on.
It was nice to meet you. Thank you so much.
This has been Everyday Injustice. I'm your host, David Greenwald. Join us again next time for more tales from the injustice system.